Welcome and thank you for joining SciFarth's webinar, California Background Check and Cannabis Update. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Pam Devada. Pam, you may begin.
Thanks so much, Brooke, and welcome everyone. I'm thrilled to be here with Jen Mora so that we can talk a little bit about some of the updates that have been happening in the world of California in terms of background checks and cannabis. We've got a short webinar today because while there are a lot of updates, we thought it would be better to do sort of a, instead of a huge deep dive, really to do a short webinar so that you could get sort of the nuts and bolts, given the fact that some of these new regulations are already in place. So without further ado, you saw our legal disclaimer. Jen and I work together all the time on areas related to everything related to pre-employment, post-employment, background checks, litigation, compliance, and defense. And Jen has a specialty area in addition to having all of that information with the background check issues dealing with cannabis throughout the country. So what are we going to cover? Well, we're going to start off, if we can go to the next slide, by talking a little bit about the California Fair Chance Act, what it already has in store. We're then going to spend the bulk of our time talking about the amendments with the Fair Chance Act regulations that did go into effect October 1st, talking a little bit about some of the new cannabis protections where Jen's going to take the lead on that. And then we're going to end with our closing thoughts and best practices. So without further ado, let's go ahead and dive in. I'm going to turn it over to Jen. Welcome. If you want to chat a little bit and tee us up about sort of where we already are with California Fair Chance Act, and then we'll go ahead and get started with then the regulations and some of the amendments.
Pam, good morning or good afternoon, depending on where you're calling from today. I'm going to warn you in advance, I have a noisy dog in here. He's about ready to calm down, but just kind of an FYI. That's this new Zoom world we're in. So I'm going to talk briefly about what the California Fair Chance Act currently requires, so you can kind of get a framework for what Pam will talk about, which are the changes that have been made. California's Fair Chance Act has been in place since January 1 of 2018, and it essentially is like a ban the box law. I mean, that's essentially effectively what it is. You've probably been hearing this term pop up all over the country. A ban the box law started out as a law that said employers cannot include the have you been convicted of a crime question on an employment application. And so what that means is that employers have to wait until a different time in the hiring process to ask about and consider criminal history. In California, since January 1 of 2018, it has been the case that you cannot make any inquiry about criminal history until after the person gets a conditional offer of employment. Inquiry is defined broadly to also mean you can't go check, Google, you can't order a criminal history background check. You really have to make sure somebody gets through the process, they get an offer, and then you order or ask about criminal history. It's long been the case under Labor Code 432.7 that employers can't ask about or consider arrest or charges that didn't lead to a conviction, except in very, very narrow cases that we won't talk about here. Referral to or participation in a diversion program. It used to be the case that the law said you couldn't consider those at all, but the regulations were amended a couple years ago to say that you can consider them as long as they're currently in the program. The law now is that once the probation has been completed and the case has been dismissed, it's off limits. Convictions that have been sealed, dismissed, expunged, or eradicated, that's been on the books for a number of years. And then recently, a couple of years ago, the federal or the state agency that enforces the Fair Chance Act added cases where somebody has a certificate of rehabilitation or pardon cases. So those have been off limits for quite some time. Next page. Essentially, in California, you should just be considering convictions. We're not going to talk about pending cases. That could be an entire 1-hour webinar, but think conviction and you're good. California's Fair Chance Act since 2018 has required, similar to the EEOC's 2012 enforcement guidance, that you do an individualized assessment. So this is an 8-factor analysis where you're doing a big picture look at somebody's conviction. How long ago did it happen? What was the nature? Was it a felony or a misdemeanor? Do they have any sort of evidence of rehabilitation, things like that. One thing we should note is that Los Angeles and San Francisco both have separate ban-the-box laws. We're not going to go into those. I think San Francisco has mostly been gobbled up by the state version. Los Angeles does have a wonky law that you do need to consider. So once you do your assessment in California, there also are what we call pre-adverse and adverse action notices. That's language that we've stolen from the Federal Fair Credit Reporting Act. If you recall, the FCRA says that you have to follow a 2-step notice process to give somebody an opportunity to consider the information in the report before you make a decision. California requires that notice process whether you find out about the conviction from a report, or if you've maybe asked the person directly, tell us about your convictions, or maybe you found out about something from your own public record search. So you have to give them a copy of the report. You have to specifically identify in the letter the conviction at issue. You have to explain they have the right to respond before a decision becomes final. And then you have to tell them, hey, if you want to give us evidence of rehabilitation or any other mitigating evidence, you have a right to do that. Next page, please. There's a dispute process. The applicant has 5 business days to respond. The employer does not have to, but can explain its reasoning. We don't know any employers that actually do that in Los Angeles. You do have to actually do that on a form. They get 5 business days, and then if they advise the employer within that 5 business days that, look, this information is inaccurate and I'm getting information to prove that, then they get an additional 5 business days. If they give you any information, evidence of rehabilitation, you know, I'm now in AA, I'm going to church, I'm a volunteer, all these things, you have to consider that before you make a final decision. And then once you decide if I'm not going to hire them, whatever they said didn't make me change my mind, you have to follow up with an adverse action notice, advising of the denial or disqualification. If you have any existing procedure to appeal, most employers don't, but if you did, you would have to explain that. And then the right to file a complaint with the Civil Rights Department. It used to be the Department of Fair Employment and Housing, and then a couple years ago it was changed to the CRD. So that's in that shell. That's going to give you a framework for us now turning it over to Pam, who's going to talk about what is it you need to know now because these amendments were effective as of 17 days ago on October 1st. Pam?
Thanks so much, Jen. Appreciate it. You know, we've had a lot of questions on that adverse action notice and whether or not you actually have to amend your adverse action notices, and you do, because you need to make sure that it specifically says the Civil Rights Division. Probably should have done that previously. There's not a change to the pre-adverse action notice. All right, so let's dig in and figure out what actually has changed with these new regulations. So as Jen said, we've got new amendments to the Fair Chance Act regulations. They went into effect October 1st. So what do you need to do? And we get tons of questions from employers of specifically, what do I need to change in my process? So the good news is that if you've actually been following the Fair Chance Act, there's not that much that you really need to change. We're going to focus on the specifics, though, of some of the changes and some of the amendments where you could really focus on to understand what you need to do. What has not changed? Post-conditional offer requirement still applies, as Jen indicated. But what has been changed, or at least clarified, is that post-conditional offer requirement now applies to current employees as well. So what that means is, for example, if you have a current employee who is going to be in line for a promotion, and you are going to be dealing with something as it relates to their conviction, whether it's as part of their background check, for example, and or evaluating their criminal history, you're going to need to provide that individual an offer for whatever that is, whether it's an offer for promotion, training, discipline, etc. Similarly, if there's a change in company ownership, and so there's going to be an employee going from one company to another company because of a corporate change, you're going to want to make sure to have that offer done ahead of time. Similarly, internal and external job postings cannot say anything about the fact that somebody with a criminal history will not be considered. You may have heard, you know, on the other coast, if you will, in New York City. New York City has their own Fair Chance Act. We're not talking about that today, but I'm just as a comparison, right? That specific law mandates that an employer cannot mention anything about criminal history unless and until an offer of employment has been given, and it can only be conditioned solely on the criminal history. So similarly, in California, the new regs now say that any job posting cannot indicate that somebody with a criminal history will not be considered. The regulations also talk about what happens when you learn about this information on some sort of volunteer basis. So for example, if you're in an interview and you are an employer and you've got an employee or a potential applicant who is indicating that they have some sort of criminal history, you have to ignore that unless and until you make an offer of employment. After you make an offer of employment, then you can consider in line with the regulations and the Fair Chance Act as well. But you have to ignore it if it's going to be, if it's volunteered by an applicant. The amendments also discuss regulated employers. So the good news is that there is still an exemption. For example, if you are a regulated employer and you must run a background check or you must disqualify someone based on certain criminal history, that exemption still applies. What the regulations did, though, is that they specifically clarified that that exemption does not apply if, for example, somebody else has to run the check. So, for example, a federal agency or a licensing body or somebody else has to run the check. That doesn't mean that then that exemption is applicable to you. So it's a little bit more narrowly interpreted than it used to be. You'll find that as a theme. For example, many of the things that the regulation did is they narrowed some of the specific exceptions or exemptions under what the law is. However, they expanded the definition of employer. So for example, instead of just being a regular direct employer, of course, the regulations apply to that. It also now, these regulations are going to apply to indirect employers. So agents or staffing companies. So if you are a staffing company or if you utilize a staffing company, understand, or staffing agency, understand that these regulations are likely going to potentially apply to you as well. So it's much broader in terms of who these regulations apply to. If we could go to the next slide. The regulations also make clear that you're still going to need to do an individualized assessment. Remember, you've got the EEOC guidance, which is not regulations, that is sort of at a federal level. You also then have these state laws and now these regulations. And so individualized assessment is still going to be required under the new regulations and the amendments. What has been clarified, though, is that you're still going to have to look at the nature and the gravity of the offense, but they're broadened to say, for example, has there been something else, for example, a disability, trauma, domestic or dating violence, assault or stalking, human trafficking, duress, or other things that contributed to the conduct? You're still going to have to look at the time that has elapsed since the offense or the conduct, and what they're really focused on is not only the completion of the sentence, but when did the behavior actually happen? You know, was the person in the court system for multiple years? So when was the actual offense that occurred, as well as if there was any sort of completion of the sentence, and the nature and the hell of the job held or sought. What is, I'll call, a little bit different in the interpretation here is that the regulations now specifically say that employers, and again, the broad definition of employers, must do an initial assessment before the pre-adverse notice. Now, look, a lot of employers are already doing this, but if the argument is, if you would be sending out a pre-adverse notice, waiting to gather the information to do any sort of analysis, that may not be enough anymore. So for example, you're going to need to potentially consider, do you need to amend your process of how you gather the information? You know, Jen and I have long been proponents about asking about criminal history at the right time, post-conditional offer, with the right legally required question that we'll talk about in a few minutes as well, to gather certain information, right? That's an opportunity that you may have when an applicant may be able to provide you with information that you need in order to perform that individualized assessment, that initial individualized assessment, and to look at things like the nature of the gravity of the offense, the time, the nature of the job held, and all of those other pieces of information. So the key takeaway here, though, is if you're going to be gathering all of that information in the pre-adverse action letter, it may or may not be sufficient. So you're going to have to look at your analysis of how you're getting the information, when you're getting the information, where you're getting the information, and is it enough or not. If we can go to the next slide. The regulations also had some additional amendments and added some more information around the type of evidence that an applicant or an employee could submit in terms of rehabilitation or mitigating evidence. What's interesting is that now they have really focused on, this is really the first time we've seen this in any state or local jurisdiction, that talks about you, that as an employee or applicant, that they can provide information relating to trauma, domestic or dating violence, assault, or other factors to say, this is why, for example, these factors contributed to my either offense or the conduct that are mitigating. Similarly, now you have to also consider if someone provides you information relating to a disability like past drug addiction, mental impairment, and if that contributed to their conduct and or their offense or conviction, you need to take that into consideration. And if it did, the likelihood of any harm arising from similar conduct and whether or not that could be eliminated or mitigated by a reasonable accommodation. What you cannot do is say, fill out this form, and if you don't fill it out, we won't consider it. You have to consider any information that an individual provides you basically in any different form that they provide it in. So it doesn't have to be, for example, a formal written document or formal notice. It can be provided in any way, shape, or form. Similarly, you may still have to require or may still have to do a reassessment if additional information is provided. Jen talked about the LA Fair Chance Act, and that has a very, very specific assessment form, and if additional information is provided, a reassessment. It's similar now in California as well. If we can go to the next slide. The last thing that the amendments do is, in terms of the timing, they clarify the specific timing. And so now applicants or employees have at least 5 business days from the receipt of that pre-adverse action notice to respond with additional information. Again, this is very similar to the New York City law that talks about not when it's sent, but when it's actually received. There's a lot of information and I would say consternation and confusing about the timing prior to these amendments. Now the regulations really do remove any ambiguity over when that notice is received. So specifically, if you send information in a format that does not have a specific formal confirmation of receipt, it's going to be deemed received based on how you deliver it. 5 calendar days if you mail it in California, 10 calendar days if you mail it from outside of California, 20 calendar days if it's mailed from outside of the United States, going to be rare, and then 2 business days if that's emailed. Again, if you get returned information, then you got to sort of start over because, you know, obviously it's not going to be deemed received if you now know, for example, that it's been returned. Without further ado, I'm going to pass it back over to Jen to talk a little bit about the cannabis protections and some of the new issues that we've seen as it relates to California. Jen?
Thanks, Pam. And I do want to clarify something because it's coming up in the chat. Just to be clear, if your letters are referring to the Department of Fair Employment and Housing, they need to change to the California Civil Rights Division. It's the same agency, but they changed their name. So just make that minor edit. And before I turn over to Cannabis, I again want to apologize for the dog. We got rid of him, so hopefully we're good. Okay. So next slide, please. We're going to talk about AB 2188, which is effective January 1, 2024. And I'm a little surprised that California took as long as it did to provide employment protections to those who use cannabis, but it is what it is. California did become the first state in the country to actually start digging into the science behind testing. And so for this reason, it's actually really important for everybody to understand testing methodologies. The primary psychoactive agent, which is the thing that gets people high in cannabis, is THC. And most employers are using urine drug tests, which targets cannabis metabolite THCA, which is non-psychoactive. So when an employer is getting a urine test result and it shows they're positive for THC, all that's saying is that the person has used it sometime in the past. It could have been days or weeks. When actually, we don't even know. So I want to be very clear about something before I get into this particular law. There is no scientifically valid drug test right now on the market that will tell an employer whether somebody is impaired at or near the time they provide their specimen, period. One of the things that the state did, and it was a bad idea, in my opinion, is they wrote, when they wrote this law, they put in the findings a statement that employers have available to them a bunch of tests that will prove impairment, and that's simply not true. So let me talk a little bit about the law. What it says is that it's essentially making cannabis users a protected class in California, and the reason we think that is because they added all of these protections to the Fair Employment and Housing Act, which is our anti-discrimination and anti-harassment statute. So starting on January 1, it is unlawful for employers to discriminate against somebody because of either one or two things. Let me move my deck over here so I can read this. They're either using cannabis off the job and away from work, or an employer is using drug testing that has found the person to have the non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily fluids. There is no exception for safety-sensitive roles. You'll see the exceptions here. It's essentially anybody working in a building and construction trade or certain regulated positions like DOT where they actually absolutely have to be tested. What does this mean for you? So you have to start with the second section, which talks about an employer cannot anymore use a drug test that tests for the non-psychoactive cannabis metabolites. And since that's urine, as of January 1, 2024, what we're recommending is that employers switch to oral fluids because that actually does test for the psychoactive THC component. Now, that's for pre-employment and during employment. The second issue is that employers can't discriminate against somebody for using off the job and away from the workplace, so that's the first bullet. There is an exception in there where it says that so long as you get your methodology right, so you're switching to oral fluids, you can reject a job applicant, at least that's the way we read the law. It's going to be if we can go to the next slide, it's going to be very, very risky, however, for employers to take action against a current employee, even based on an oral fluids drug test, because an oral fluids drug test does not tell you somebody is impaired. So let me give you an example of how this works out and how this might turn into a claim for an employer. If you have an employee who comes to work and maybe they just kind of stink a little bit of marijuana and you give them an oral fluids test and they test positive and you fire them, and they file a claim, their argument is going to be, well, I used it the night before. And since oral fluids only tells us somebody is used within the last 24 hours, you have no way of saying, no, that's not true. You actually used an hour ago because I could smell it on you. So it's going to be really, really risky for employers, even using oral fluids, to take action against somebody for a positive test result. So, you know, you can work on developing a very strong and robust reasonable suspicion drug testing policy and take action if you absolutely are sure, based on all your evidence, they smell, they're stumbling around, they're slurring their words, maybe they were fine before lunch, they went to lunch, they came back, and that's when all of a sudden they smell funny. But ultimately, at the end of the day, if you get a claim because you've terminated for somebody for marijuana use, your evidence is going to have to be, based on everything we know, they were high while at work or they were under the influence or impaired, and the test isn't going to help you with that. So be very careful. I know that there's a lot of oral fluids tests out there that are saying this is the solution to all your problems in California. Be very, very careful about that, because I don't think the California legislature really thought this through. So it's creating a lot of issues and questions for employers. One thing I will add is just a couple of weeks ago, Gavin Newsom amended AB 2188 to say that employers are now prohibited from considering past marijuana use. So Pam had talked about that questionnaire where we asked, have you been convicted of a crime? Prior to this, there was an instruction for California that said, don't tell us about non-felony marijuana convictions that are older than 2 years. Now what it essentially has to say is, don't tell us about any prior conviction relating to use or possession of marijuana. Now, distribution and sale and things like that, trafficking, which we rarely see anyway, aren't going to be an issue, but that's just something that you need to keep in mind. So with that, next slide, please. We have a CLE code that I need to read out.
Yep, I've got it, Jen. It is SS5471. So S is in Cybarth, S is in Cybarth, 5471. If you are interested in and would like to get CLE credit.
So with that, I'll turn it over to Pam to wrap up for us. Thank you for attending, everybody.
Great, and we've been trying to get to the questions as they've come in. So if you do have additional questions, feel free to put them in the chat, and we will try and get them. We can certainly reach out to you as well afterwards. If we can go to the next slide. In terms of closing thoughts, I think that the biggest thing to think about here is, number one is, and we will be sending out copies of the slides to all attendees, it's really important to keep abreast of the changing laws. As you saw, as Jen was indicating, we've got changes that happen all the time, unfortunately, with these laws, some of which, give you some lead time and some of which don't. And then the other thing that we're going to see is how the agencies here and some of the litigation is really going to show the interpretation of this. In terms of closing thoughts, though, and best practices, we certainly would recommend that if you have not had a chance to have your background screening policies and processes, forms, and procedures reviewed, consider doing that. Obviously, you've got the Federal Fair Credit Reporting Act. If you're using a third-party consumer reporting agency that may apply to you, you may be working with a background check vendor or partner, and that's perfectly appropriate to do, but understand that if you're utilizing forms or processes that they have, that you make sure that you're complying as an employer with the law, because of course it's going to be your responsibility to not only comply with the Fair Chance Act, the new amended regulations, and then also some of the new cannabis laws as well. We really strongly recommend that you have sort of a centralized review or centralized process that can be on the front lines. It can be, a committee of individuals. It can be one or two individuals, but for consistency, that's very, very helpful. It's also going to be helpful so that you understand when there's a change in the law, for example, that someone who's making a decision in a different state understands these new regulations as well. And then in terms of some of the other best practices, consider the future of cannabis testing in California and beyond, as Jen was saying, really make sure that you understand what the regulations are, what the laws are, make sure that you're going to be asking the right questions, but falling back on sort of what used to be is not going to, it's not going to put you ahead of the curve, and it's probably going to put you into potential legal hot water. So with that, we've got 1 minute of time, so I'm going to look to see if the questions to see, I'll pass it over to Jen to see if she has any further closing thoughts, and then we'll look at and see if we've got any other questions that we haven't answered yet. Jen, any final closing words? Oh, you're on mute, I think.
I think one question that comes up a lot in both the cannabis and the background check space is which law applies if, for example, you have somebody who lives in Texas, but they're traveling here for a period of time, or maybe they're here and they're leaving the state. Can we test people? And, that's always a tricky question you should work with your counsel on. But in our view, if you can be sued here, then you should follow the law here. Particularly with respect to the cannabis and even the Fair Chance Act, they're both under the Fair Employment and Housing Act, which are anti-discrimination statutes. So I don't think you can really get away with, well, we're not going to follow that because somebody is now in Texas for a couple of weeks. So I would just be a little bit careful on that. And yes, everybody's going to get the slide deck in the presentation, so that's not an issue. And employers who are exempt from AB 2188, building and construction and DOT workers, If you're a federal contractor, check your contract, see what it says. Just because you're a government contractor doesn't necessarily mean you're exempt, because the Drug-Free Workplace Act is completely silent on testing. So that's my last thought. I don't know if Pam has anything else.
Just a very sincere thank you to everyone. If we didn't answer your question, we'll try and look through these. If you need more information, Jen and my email is on this slide. Thanks very much for your attendance today with this quick webinar. We appreciate it. Have a great rest of your day, everyone.
Thanks, everybody.